हाय फ्रेंड्स, हम आईएएस बाबा का 60 डे प्लान डिस्कस कर रहे हैं। तो हम पॉलिटी का क्वेश्चन देखेंगे। सो टॉपिक हियर यू कैन सी कॉन्स्टिट्यूशन, हिस्टोरिकल बैकग्राउंड, मेकिंग ऑफ द कॉन्स्टिट्यूशन, फिलोसफी द कॉन्स्टिट्यूशन, यूनियन एंड इट्स टेरिटरी, सिटीजनशिप। ओके, सो लेट्स स्टार्ट। फर्स्ट क्वेश्चन, which of the following pairs are correctly match institution of speaker in the role of role. Okay, here which is the correct match? Here you see the answer 2 and 3 is the answer. The institution of residual power from Canada. Okay, so institution of residual power Canada and law making procedure United Kingdom. Here you can see in institution of speaker and her role is taken from UK British Constitution. The other two statements are correct. Okay, Government of India Act 1935, federal scheme, also from Constitution of Canada, Office of Governor, Judiciary, Public Service Commission, Emergency Provision, Administrative Details, British Constitution, Parliamentary form of government. Okay, the idea of struggle, single citizenship, the rule of law. Okay, institution of speaker and his role, law making procedure established by law, and US Constitution preamble. We're taking different things like preamble, fundamental rights, federal structure. Okay, so federal structure and other things, independent of judiciary and separation of powers and the three branches. Okay, of the government: judicial review, president, and supreme commander, and other things. Supreme commander of armed force, president. Okay, equal protection of under law. Irish Constitution, directive principles of state policy. Is Australian Constitution, freedom of trade and commerce, and within that country and between the states, power of the national legislature to make law for implementing treaties even on matters outside normal freedom jurisdiction and concurrent list. French Constitution, ideals of liberty, equality and fraternity. Canadian Constitution, a quasi-judicial form of government, a federal system with a strong central government, distribution of powers between the central government and the state government, residual powers, okay, retained by the central government. Constitution of Soviet Union, fundamental duties, taking its Weimar Constitution, Germany, emergency provision under the Article 356, South Africa, amendment of Constitution, Japan, due process procedure of law. Okay, so here is source given, making of the Constitution. Okay, so you can remember all the things. So here you can find answer, take the answer. Okay, so let's go to the other question. Second question, which of the following are the features of parliamentary form of government? Which are the features of parliamentary form of government? Parliamentary form of government, here answer is C, 2, 3 and 4. Leadership, parliamentary for leadership of the chief minister, collective responsibility of the executive, parliament, and membership of the ministers of the legislature. So bicameralism is not answer. Others 2, 3, 4 are correct. Leadership. Okay. So parliamentary form of government, leadership of the chief minister, and collective responsibility of the executive to the parliament, membership of the minister in the legislature. Bicameralism is not essentially a feature of the parliamentary democracy. The parliamentary system is known as Westminster model of government. Responsible government and cabinet government. The constitution establishes the parliamentary system, not only at the center but also the states. The feature of parliamentary government in India are feature of the parliamentary form of government. What is presence of nominal and real executive, majority party rule, collective responsibility and executive up to the legislature, foundation, principle of parliamentary government, membership of the minister in the legislature, leadership of the prime minister or the chief minister, resolution of the lower house, Lok Sabha or assembly. Indian parliamentary system is largely based on the British pattern. There is some fundamental difference between the two. For example, Indian parliament not a sovereign body like the British parliament, but the Indian state has an elected head, while the British state has hereditary state head, monarchy. Indian head is republic and British state has hereditary head, monarchy. In the parliamentary system, whether in India or Britain, the role of the Prime Minister becomes so significant and crucial that the political scientists like to call it a prime ministerial government. Okay, and here you can source after the Great Revolt of 1957, the British government after the Great Revolt 1857, the British government felt the necessity of seeking the cooperation of the Indians in the administration of their country. In pursuit of the policy of association, many acts were enacted. 1987. Okay, which act introduced for the first time bicameralism and direct election in the country? It is the Montagu-Chelmsford reform. Okay. B is the correct answer. Okay, so Montagu-Chelmsford reform, bicameralism and direct election of the country. Okay, on August 20, 1970, the British government declared first time that the objective was the gradual introduction by the responsible government in India. The Government of India Act 1919 and thus enacted, which came into force 1921. This act also known as Montagu-Chelmsford reforms. Montagu was the Secretary of State for India and Lord Chelmsford was the Viceroy of India. It relaxed the central government over the provisions by demarcating and separating the central and provincial subjects. However, the structure of the government continued to be centralized and unitary. It further divided the provincial subjects into two parts, transferred and reserved. Transferred subjects were to be administered by the governor and with the aid of ministers responsible to the legislative council. The reserved subjects, on the other hand, were to be administered by the governor and his executive council without being responsible to the legislative council. Thus, this dual scheme of governance was known as diarchy. It introduced for the first time bicameralism and direct election in the country. Thus, the Indian Legislative Council was replaced by a bicameral legislature consist of an upper house, Council of States, and lower house, Legislative Assembly. The majority of members of both the houses were chosen by direct election. It required that the three of the 6 members of the Viceroy's Executive Council, other than the Commander-in-Chief were to be Indian. It extended the principle of communal representation. Here you can see the Council of State upper house, okay, and Legislative Assembly lower house, okay. Next, it extended the principle of communal representation by providing separate electorates of Sikhs, Indian Christians, Anglo-Indians, and Europeans. It granted franchise to a limited number of people on the basis of property, tax, or education. It created a new office of the High Commissioner for India in London and transferred to him some of the functions hitherto performed by the Secretary of State for India. It provided for the establishment of a Public Service Commission. Hence, a Central Public Service Commission was set up in 1926 for recruiting civil servants. It separated for the first time provincial budgets from the central budget and authorized the provincial legislature to annex their budgets. It provided for the appointment of a statutory commission to inquire and to report on its working after 10 years on its coming into force. So next question. With regard to preamble of the Indian Constitution, consider the following statements. Okay, so you can read it. The answer is B. 2 and 3 is the correct. So preamble. The preamble is a part of the Constitution. It was held by the Supreme Court as not a part of the Constitution in very Indian case. It was held by the Supreme Court as not a part of the Constitution in very Indian case. Now we start reading it. The preamble embodies basic philosophy and fundamental values, political, moral, and religious, on which the Constitution is based. The preamble cannot override the specific provisions of the Constitution in case of any conflict between the two. The latter shall preamble as part of the Constitution. Okay, so one of the controversies about preamble is as to whether whether it is a part of the my goal is no. I'm sorry. Health अच्छा नहीं है. Very Union case 1916, the Supreme Court said that the preamble shows a general purpose behind the several provisions in the Constitution, and it thus key to the minds of the makers of the Constitution. Further, where the terms used in any articles are ambiguous or capable of more than one meaning. Next, the Kesavananda Bharati case. The Supreme Court in 1973, the Supreme Court rejected the earlier opinion and held that preamble is a part of Constitution. It observed that the preamble is of extreme importance and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. In the LIC of India case, the Supreme Court again held that the preamble is an integral part of the Constitution. In India, who is constitutionally empowered to act as the final interpreter of the Constitution? Final interpreter is Supreme Court. Article 13, Judiciary, and under Article 13, Judiciary has power to void any provision of laws, actions of the executive. Federalism is a key feature of the Indian Constitution. Which of the following statements concerning this is incorrect. Federalism is a key feature of the Indian Constitution. Which of the following statement concerning this is incorrect? So, incorrect is, since the state governments are autonomous political units and the central government cannot enforce any order. Okay, it is incorrect, but others are correct. Like the both central federalism is a key feature of the Indian Constitution. Yes, it is. Both central and state government have been established the Constitution. Okay, both government derived their power from the Constitution, and the Indian citizens are governed by laws and rules made by both central and the state governments at the same time. In India, through the state government autonomous political units, the central government can enforce an order on them. For instance, in times of emergency. Okay, which of the following is not a pillar of the parliamentary democracy in India? Which of the following is not a pillar of the parliamentary democracy in India? Separation of powers. Okay, separation of powers deal with the ensuring equitable distribution of powers between agencies of states, namely executive, judiciary, and legislature, and can be integral to any kind of polity and not specifically up to parliamentary democracy. Consider the following statement regarding Constituent Assembly of India. One is the correct answer. Correct word. Okay, it is constituted under the scheme formulated by the Cabinet Mission Plan. Okay, regard to Constituent Assembly, it is constituted under the scheme formulated by the Cabinet Mission Plan. Okay, the Constituent Assembly was constituted in November 1946 under the scheme formulated by the Cabinet Mission Plan. The Constituent Assembly was to be a partly elected and partly nominated body. Moreover, the members were to be indirectly elected by the members of the provincial assemblies, who themselves were elected on a limited franchise. The election to the Constituent Assembly for 296 seats allotted to the British Indian provinces were held in July-August 1946. The Indian National Congress owned 208 seats, the Muslim League 73 seats, and small groups and independents got the remaining 15 seats. Okay, however, the 93 seats allotted to the princely state were not filed as they decided to stay away from the Constituent Assembly. Although the Constituent Assembly was not directly elected by the people of India on the basis of adult franchise, the Assembly comprised representation of all sections of Indian society: Hindu, Muslim, Sikh, Parsis, Anglo-Indians, Indian Christians, SC, ST, introducing SC, ST, and including women, all these sections. The Assembly included all important personalities of India at that time, with the exception of Mahatma Gandhi and M.A. Jinnah. Next question. Consider the following statements. In India, here all correct, you can read it. In India, select the correct code. Okay. In India, both the citizens by birth as well as naturalized citizens are eligible for office of president. Okay, it is right. Parliament has the power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to the true citizenship. So, okay, next question. The Federation, as prescribed by Government of India Act 1935, never come into being because B the answer. It was optional for the Indian states to join the federation. The federation was prescribed as prescribed. The Government of India Act 1935 never come into being because it was optional for the Indian states to join the federation. Okay, suppose the Parliament of India wants to form a new state X, then which of the following articles should be invoked? It is Article 2. Article 2 will be invoked. Okay, should be invoked. The part 2 admits Article 2. The Article 2 grants two powers to the Parliament. To the Parliament, the power to admit into the Union of India new states, the power to establish new states. Okay. Article 3, on the other hand, relates to the formation or changes in the existing states of the Union of India. Okay. And internal readjustment interest of the territories of the constituent states of the Union of India. Consider the following statements. Okay, which is the correct? Here A and R are true, and R is the correct explanation of A. A is the correct answer. Okay. So now this is the Parliament can review the political map of India according to its will. Parliament cannot redraw the political map of India, and the territorial integrity of any state is not guaranteed by the Constitution. Consider the following statements. The answer is B, 2 only. The preamble was enacted by the Constituent Assembly after the rest of the Constitution was already enacted. Parliament was enacted by the Constituent Assembly, and rest of the Constitution was already enacted. The preamble is neither a source of power to legislature nor a prohibition upon the powers of legislature. It is non-justiciable, thus that is, its provisions are not enforceable in courts of law. Like any other parts of the Constitution, the preamble was also enacted by the Constituent Assembly, and after the rest of the Constitution was already enacted. It is to ensure that it was in conformity with the Constitution as adopted by the Constituent Assembly. Which of the following provisions of the Constitution reveal the secular character of the Indian states? So it is all. Okay, which reveals the secular character of the Indian state? Article 30, Article 14, Article 29 and Article 44. The following provision of the Constitution reveal the secular character of the Indian state. The term secular was added to the preamble of the Indian Constitution by 42nd Constitutional Amendment Act 1976. The preamble secures to all citizens of India liberty of belief, faith and worship. Again, and the state shall not deny to any person equally before law or equal protection of the law. Article 14. The state shall not discriminate against any citizen on the ground of religion. Article 15. Equality of opportunity for all citizens in matter of public employment. Article 16. All persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate any religion. Article 25. Article 26. Every religion, denomination or any of its sections shall have the right to manage its religious affairs. Article 26. Article 27. No person shall be compelled to pay any taxes for the promotion of a particular religion. Article 27. Article 28. No religious instruction shall be provided in any educational institution maintained by the states. Okay, no religious instruction shall be provided in any educational institution maintained by the state. Article 29. Any section of citizens shall have the right to conserve its distinct language, script or culture. Article 29. Article 30. All minorities shall have the right to establish and administer educational institution of their choice. Article 30. The state shall endeavor to secure for all the citizens a uniform civil code. The state shall endeavor to secure for all the citizens of a uniform civil code. The Western concept of secularism connotes a complete separation between the religion and the state. This negative concept of secularism is inapplicable in the Indian situation, where the society is multi-religious. Hence, the Indian Constitution embodies the positive concept of secularism, that is giving equal respect to all religions or protecting all religious equally. Moreover, the Constitution has also abolished the old system of communal representation, that is, reservation of seats in the legislature on the basis of religious. However, it provides for a temporary reservation of seats for the scheduled caste and scheduled tribes to ensure adequate representation to them. Allocation of seats in the Rajya Sabha to the states and the Union Territories is mentioned in 4th schedule. Okay, allocation of seats in the Rajya Sabha to the states and Union Territories. Okay, 4th schedule. Second schedule. What is second schedule? Second schedule here describes provisions relating to emoluments, allowance, privileges of president, speaker, judge. Okay. Third schedule, forms of oath or affirmation. Fourth schedule, to second, allowance, privileges of president, speaker, judge. Okay. And third schedule, forms of oaths or affirmation. Fourth schedule, allocation of seats in the Rajya Sabha to the states and the UT. Eighth schedule, language recognized by the Constitution. Okay, 8. Okay, next, Constitution consider the following statements about Zhuang tribe. Okay, Zhuang tribe. B is the correct answer. Zhuang tribe is identified as particularly vulnerable tribal group. Okay, Zhuang tribe. 10,000 population just. Jaipur district, Odisha. The quantum experiment at space scale quiz, the world's first quantum satellite. Okay, it is established hard proof communication between space and the ground. Launched by China has launched first directed testing fundamental satellite. So, consider the following states. Is the first state the country to draft its own internal security act. It is Maharashtra drafted its own international security act. Consider the following statements. Correct is okay. Brihadeshwar temple. Okay, Brihadeshwar temple's feature is it is dedicated towards Lord Shiva. It is also a part of UNESCO World Heritage Sites as great living Chola rulers, Chola temples. It is popularly known as Big Temple. Okay, Brihadeshwar temple. Built by Raja Chola I. Consider the following statements about Comprehensive Convention on International Terrorism. Here is the correct answer. 2. It addressed the issue of Pakistan alleged support for cross-border border terrorism in South Asia. Okay, next, consider the following statements about genetic engineering appraisal committee. The answer is A, one only. It is established under Ministry of Agriculture and Farmers Welfare. Genetic engineering appraisal committee, Ministry of Agriculture and Farmers Welfare under. Established under Ministry of Environment, Forest and Climate Change, apex body. Okay. Correctly match which? D is the correctly match, none of the above. Here he given Jian place and country. Here you can see Jian in China, News, Ashgabat, Turkmenistan, Aleppo, Syria. Okay, now our topic: fundamental rights, fundamental duties, and directive principle of state policy. Okay, Article 15 provides that the state shall not discriminate against. Okay, here you can study 22 question. I will study again others. Article 15 provides that the state shall not discriminate against any citizen on the grounds of religion, race, caste, and sex, and place of birth. Okay, so here be what does the word only signify here? Here B is the answer. Discrimination on grounds is not prohibited. Article 15, okay, the state shall not discriminate against any citizens. Okay, on grounds only of race, religion, caste, sex, place of birth. Okay, so here two crucial provisions: discrimination and only. The discrimination means to make an adverse distinction. Only connotes the discrimination on grounds is not prohibited. Here with regard to access of shops, public restaurant, hotels, okay, use of wells, tanks, bathing huts, roads, okay, and the provision prohibits discrimination both the states and private individual, while the former provisions prohibit the discrimination only by the state. There are three exceptions to this general rule of non-discrimination. Tribal inhabitation protected from interference of outsiders, from owning property, commercialization activities, etc. prohibited. Recently, the Supreme Court has held reservation in promotion invalid. Instead of the following statement with regard to these 1, 2 and 3 all are correct. Reservation in promotion invalid. The state does not have under ungraded power to provide promotion in reservation to the backward class. The state must demonstrate backwardness, inadequacy and representation and maintenance of efficiency before providing reservation in promotion to scheduled caste and scheduled tribe employees. If the state does not justify this policy, it would violate Article 60. And here Supreme Court recently held that an exercise to determine inadequacy of representation, backwardness, and overall efficiency is a must before granting promotion to scheduled caste and scheduled tribes employee. Okay, Article 16 provides equality of opportunity for all the citizens in matters of employment, appointment to any office under the state. In order to nullify and rule the ruling with regard to prevention of in promotion, the 77th Amendment Act enacted 1955. Sorry. Next question. Forcible religious conversion violate which of the following fundamental rights? freedom of conscience. Okay, it violates possible religious convention, violate freedom of conscience. Okay, Sherry against in freedom of conscience, inner freedom of the individual to mold his relation with God and or creatures in whatever way he desires. Right to profess declaration of one's religious beliefs and faith openly and freely. Right to practice performance of religious worships, rituals, ceremonies, and exhibition of your beliefs and ideas. Right to propagate, transmission of and dissemination of one's religion belief to others, or exposition of the tenets of one's religion. Freedom of conscience. Okay. And next, with regard to Article 27, consider the following statement. 1 and 2 are correct. The term untouchability has not been defined in the Constitution. Untouchability. Okay. Article 17 does not cover social boycott of few individuals and their exclusion from public places. Consider the following statements. Okay. Consider the following statements. Here you all true. The principle of locus standi is not necessary in case of an order issuing right of habeas corpus. Habeas corpus can be issued against both public and private individual. Okay. Latin term literally means to have the body of. It is an order issued by the court to a person who has detained another person to produce the body of the later before it. The court has then examined the cause and legality of detention. Okay, principle of locus standi means the right can be sought by any interested person and not necessarily by the aggrieved person. Increase of habeas corpus and quo warranto locus standi is not necessary, whereas increase of certiorari prohibition mandamus locus standi is mandatory. The rate of habeas corpus can be issued against both public and private, both public authorities as well as private individuals. Consider the following statements. Okay, here one is the correct. Article 29 grants protection only to linguistic minorities and not to religious minorities. Okay, under Article 30, all minorities should have the rights to establish and administer educational institution of their choice. Next question 7, C1 to 3. With regard to directive principles of state policy, consider the following statements. These principles have origin in the Spanish Constitution. They are fundamental to the governance of the country. Dr. B.R. Ambedkar described them as noble features of the Indian Constitution. Directive principles of state policy are enumerated in Part 4 of the Constitution from Article 36 to 51. The framers of the Constitution borrowed this from the Irish Constitution of 1937, which had copied it from the Spanish Constitution. Dr. B.R. Ambedkar described these principles as noble features of the Constitution. The directive principles, along with the fundamental rights, contain the philosophy of the Constitution and the soul of the Constitution. The directive principles are non-justiciable in nature. That is, they are not legally enforceable by the court. For their violation, therefore the government, central government, state and local, cannot be compelled to implement them. Nevertheless, the Constitution Article 37 itself says that these principles are fundamental in the governance of the country, and it shall be the duty of the states to apply these principles in making laws. Which of the following does not belong to directive principles of state policy? A. Uphold and protect the sovereignty, unity and integrity of India. It is not. Okay. Here others are telling that secure opportunity and healthy development of children, protect monument and place and objects of historical importance, to organize agriculture and animal husbandry on modern and scientific lines. So Article 39 secures opportunity for healthy development of our children. Article 48 to organize agriculture and animal husbandry on modern and scientific lines. Article 49 to protect monuments, places and objects of historical importance, uphold and protect the sovereignty, unity and integrity in the fundamental duty under Article 51 CAC. So it is not. Sorry. Next, economic justice. The objectives of Indian Constitution have been provided in the preamble and the directive principle of state policy, economic justice. Okay. We are with the people's our preamble, with the peoples of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all the citizens justice, justice, social, economic, and political liberty, liberty of thought, expression, beliefs, faith, and worship, equality, equality of status and opportunity, to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Article 38 to promote the welfare of people by securing the social order, primited by justice. Social, economic, political, Article 38, and to minimize inequalities of income, status, families, and opportunities. Consider the following statements. Okay, here is the correct 2 and 3. Okay, the Parliament can curtail or repeal the fundamental right. Okay, only by a Constitutional Amendment Act. Article 33 empowers only the Parliament to restrict or abrogate the fundamental rights on the members of armed forces. Salient features of the fundamental rights. Some of them are available only to the citizens, while others are available to the all person, whether citizens, foreigners, or legal person, like corporation or companies. Most of them are available against the arbitrary action of the state, with a few exceptions, like those against the state's action and against the action of the private individuals, when the rights that are available against the state action only are violated by the private individuals. There are no constitutional remedies, but only ordinary legal remedies. Okay. Abolition of untouchability, punishable offence, and individual who practice it. They can be supposed during the operation of national emergency, except the rights guaranteed by Article 20 and 21. They are not sacrosanct or permanent. Parliament can curtail or repeal them, but only by a Constitutional Amendment Act and not by an ordinary act. Article 33 empowers the Parliament to restrict or abrogate fundamental rights of the members of armed force, paramilitary force, police force, intelligence agencies, and analogous forces. The objective of this provision is to ensure the proper discharge of their duties and the maintenance of discipline among them. The power to make laws under Article 33 is conferred only on Parliament and not to state legislature. Any such law made by Parliament cannot be challenged in any court on the ground of the contravention of any of the fundamental rights. Okay. Next, which committee recommended for incorporation of fundamental duties into the Constitution? B. Saran Singh Committee. In 1976, the Congress Party set up Saran Singh Committee to make recommendations about fundamental duties, the need and necessity of which was felt during the operation of the national emergency in 1935 to 77. The committee recommended the inclusion of a separate chapter on fundamental duties in the Constitution. Justice Shah Committee looked into misuse of power during internal emergency. Justice Verma Committee looked into existence of legal provisions for the implementation of some of the fundamental duties. The States Reorganization Commission was a body constituted by the central government of India in 1953 to recommend the reorganization of state boundaries. In 1955, after nearly 2 years of study, the Commission recommended that India's state boundaries should be reorganized to form 16 states and 3 union territories. Again, State Reorganization Commission consists of Fazil Ali, K.M. Panikkar and H.N. Kanjuru. Some of its recommendations are implemented in the State Reorganization Act 1957. In the Indian context, consider the following statements be the correct. 2. Fundamental duties were not part of the original constitution. Okay, so only some of the fundamental rights are applicable to foreigners except Article 15, 16, 19, 29, 30. Fundamental duties are not applicable to foreigners, only applicable to citizens of India. Also, they were not part of the original constitution added in 1976 through 42nd Constitutional Amendment Act. Though the rights and duties of citizens correlative and inseparable, the original constitution contained only the fundamental rights and not the fundamental duties. The framers of the constitution did not feel it necessary to interpret the fundamental duties of the citizens of the constitution. However, they incorporated the duties of the state in the constitution in the form of directive principle of state policy. Later, in 1976, the fundamental duties of citizens are added in the constitution in 2002. A constitutional government is one which places effective restriction on the authority of the state and the interest of individual liberty. Consider the following statements. Fall under fundamental duties, be the items 1 and 3 fall under fundamental duties. To develop scientific temper and spirit of inquiry and reform, and to value preserve the heritage and culture, country's complete culture. Here Article Fundamental Duties 51A. It shall be the duty of every citizens to abide by the Constitution and respect its deal and institution, the national flag and the national anthem, to cherish and follow the noble ideals which inspired our national struggle for freedom, to uphold and protect sovereignty, unity and integrity of India, to defend the country and render national service when called upon to do so, to promote harmony and spirit of common brotherhood amongst all the people of the India, transcending religious, linguistic and regional or social diversities, to renounce practices derogatory and dignity of women, to value and preserve the rich heritage of our composite culture, to develop scientific temper, to protect improved natural environment, including forest, lake, river, wildlife. Directive principle of state policy to protect and improve the environment and to safeguard forest and wildlife, Article 48A, to promote international peace and security and to maintain honorable relation with other nations, Article 51, to raise the level of nutrition, Article 47, and standard of living. Consider the following statements, following pairs. 1 and 2. Fundamental rights from USA and directive principle is this constitution. Fundamental duties derived from USSR constitution. And US constitution, fundamental duties, independent judicial review, impeachment of the president, removal of Supreme Court or High Court judge, post of Vice President, US constitution, directive principles of state policy, nomination of members to Rajya Sabha and method of election of president. Weimar Constitution of Germany suspension of fundamental rights during emergencies. Which of the following is of describe the concerns of the Indian Constitution? B. Fundamental rights and direct measures of state policy is the concerns of the Indian Constitution. Okay, because the philosophy contain the philosophy of the Constitution and is the soul of the Constitution. Okay. Directive principles and 11th fundamental rights. It is the concerns of the Constitution. Okay, ignored by the Supreme Court incorporating socio-economic rights. It was only after the landmark verdict of the Kesavananda Bharati case 1973. Okay. We consider the following statements about lion-tailed macaques. They are classified as protected species under Wildlife Protection Act 1972. Okay. Guiana Bearbori is the fine art of using lentil paste mix to create suicide design. Which of the following statement is correct? D. None of the correct. I don't see it. ADR Dhan 45 is the also known as was news recently. It is related to high zinc rich variety. Consider the following statements about human papilloma virus. See two only. Some of the human papilloma virus can cause cervical cancer. Okay. Okay. Consider the following statements with respect to National Committee on Trade Facilitation. Okay. So it is C. 1 and 3. It is in line with WTO Trade Facilitation Agreement. It is an inter-ministerial body on trade facilitation. Next, Vanuatu was recently located in Pacific Ocean. Okay. Thank you friends. Next we discuss geography. Okay, so thank you.